Thank you very much, first of all, for having me. It's great to be back in Cambridge, and it's great to be talking about something that I've been thinking about for quite a long time. I actually have to start with something that I said already before, when last time I was here presenting in Cambridge. Why are we still talking about this? And I am guilty of talking about this a lot because I wrote a PhD on this years ago, and then I was happy that it's over, so I could move on happily to other topics. But AI stayed around, so it turned out not to be such a that it is a hype that we have to acknowledge and be very clear about. But it stayed around, and at the time many of us started doing research on this topic, generative AI was very far off, and the complicated IP questions that we handle now were very far off. So, however, despite the fact that the technology, in addition to the fact that technology has moved on, actually there is legal focus on this from various policymaking, lawmaking, and courts perspectives. So the United States Copyright Office has been handling some complicated situations in terms of registration and in terms of AI-generated works. It carried out extensive consultations already in 2023 and issued a guidance on how we should actually approach AI-generated works and how the office will be approaching them. And it's currently issuing bit-by-bit reports on the basis of that consultation. So there was a first report on digital replicas sometime last year, and now in January we have a report which seeks to be a guidance as well on copyrightability. As I suppose everybody in this room knows, the UK IP office closed its consultation on AI and copyright law at the end of February. A lot of that consultation focused on the input questions, which I will not be talking about, and which turn out to be, in fact, a little bit quite important and to be the more important bit of the discussion. But there was a chunk on output, so AI-generated works. There is a very important link between the two, but the consultation is pushing into the direction of getting rid of the provision on computer-generated works, on protection of computer-generated works, under Section 9.3 of the CDPA. So I will not be digging into that provision because by now I think it is very clear, and many of us in this room have argued that provision is quite absurd. It has a lot of legal flaws, but let's take this as something we agree on. The final piece of this complicated law and policy making, and why are we still talking about this, is that there is litigation. So apparently it is very clear that the situation is not clear for the parties. There is some litigation in this country, but there is a lot more going on in the United States, and cases keep coming out and are brought up all the time. So AI-generated output. I wanted to think about this talk and make it meaningful because I thought it's a settled discussion, but I have still managed to contextualize it within what is currently going on in generative AI, so it was very helpful to have Jennifer's primer in the beginning. I will talk about originality and in that context, the role of prompts and transparency in that discussion. I will tell you a little bit about the nervous system and the beauty of it. So Matteo did a very nice introduction as well to the neurons. I'm not going into so much depth, but since copyright, for lack of a better word, is a little bit more fluffy than patent law, I have drawn some important societal concerns that are there if we were to protect AI-generated work. And my final point will be benefiting primary creators. So, first of all, subsistence of copyright law and protectability. Well, copyright originality and subject matter are the pillars that we need to go through in order to actually grant copyright protection in a work. So we have struggled a lot in this country to figure out whether we are within the skill, effort, labor, judgment, or whatever, but it is very, very clear. It has been clear for many of us, but it became incredibly clear very recently, thanks to the Court of Appeal in THJ systems, that we are in the author's own intellectual creation basket. So that is the originality standard. Like it or not, understand it or not, this is what we're working with, and we're not working with skill, effort, labor, and judgment anymore. In addition to originality, currently, there have been some recent interesting IPEC judgments grappling with subject matter scope and definition. And I will just name them because they have expanded some boundaries of the categories, but have also, and in particular, the second judgment has touched upon this post-Brexit world that we live in here and the situation in which we have to actually make sense of how these closed list of categories complies with the fact that a work gets copyright protection only if it is the author's own intellectual creation and no other criteria should be applied to it. So for the purposes of this talk, this is the second bit is slightly less relevant, but I still thought that it's important to point it out there. That in particular, the water rower judgment, if I'm not mistaken, this is the very first time where we have a clear acknowledgement that there is a clash between EU law and there is incompatibility between that standard on deriving from EU law and the notion of artistic craftsmanship. So where does that leave us on authorship? Authorship is a notion that is complicated to define. Some have studied it for many, many years, and I have always based my understanding and belief in authorship in the comparative work of authorship that Professor Ginsburg has done. And this, she extracts a very interesting and very applicable understanding of what authorship is already in 2003. And this entails two cumulative aspects. In order for somebody to qualify as an author, they need to have detailed conception of a work, as well as a controlled execution of that work. Now, she's done this work on the basis of comparative studies between common law and civil law jurisdictions, and they have tested this understanding of authorship. She's tested it with her more recent co-authors in generative AI circumstances and AI context as well. So it still holds, at least in my view, but it is really a topic for discussion. So both of these need to be ticked. And in the next bits, I will look at how that works with prompts and how that translates into generative AI. But the idea and the rationale behind this authorship concept comes from the fact that there is something more than investing in a work, that authorship that an author is doing. So copyright cannot be understood, she says, as a merely grudgingly tolerated way station on the road to the public domain. An author is and should be a human creator who, notwithstanding the constraints of her task, succeeds in exercising minimum personal autonomy in her fashioning of the work. Because, and to the extent that she minds the work to her vision, she's entitled not only to recognition and payment, but to exert some artistic control over it. And if copyright laws do not derive their authority from human creativity, but instead seek to merely compensate investment, then the scope of protection should be rethought and perhaps reduced. And I felt that it's important to put the quote in full and to read it out because especially the last bit is something that drove a lot of my thinking behind this and should be thinking a lot of our thinking behind actually expanding copyrights for AI-generated works. Copyright comes with a very long term of protection. Some believe it's too long, It's a life general plus 70 years. And comes with a basket of very strong economic rights. So what you get once you tick the box of protectability is quite a lot. And we should be very careful in doing that. And I'm very conscious of the fact that the title of my talk is Copyright and Related Rights. And it's not just authorial copyright. But also I'm conscious of the fact that I've been given 20 minutes. So I'd like to really zoom on to the importance of authors. Once again, because I felt that we've done that, but it feels like it is needed to be stressed and stressed. Now, thinking a little bit of prompts, I'm not going to repeat the generative AI breakdown and how they work, but essentially these instructions that we give to these systems and thinking about controlled, detailed conception and controlled execution, the prompt, the generative AI and the prompts might even meet the detailed conception limb of the test, provided that they are detailed enough. So we have seen circumstances, and there have been cases a lot in front of the US Copyright Office, where the prompts have been hundreds and hundreds, and the iterations of them have really might even satisfy this detailed conception. The level of detail of the prompts can be very, very high. But that is just not one aspect. The controlled execution within these systems fails. There is a gap between the prompt and the resulting output. And the instructions do convey unprotectable idea. But for the human being behind it, for that alleged author, it's not possible to oversee, to direct, and to understand these contributions of the commissioned AI. And we might get to systems which allow for that possibility to oversee, direct, and understand. But at the moment, and it's confirmed by what Jennifer was saying earlier, we're not there. And it's not that an author needs to be controlling every single bit of the creative process. We have all been authors and written things and created things in various domains. But it is not the question of actual predictability of that outcome, is the degree of control. And here it still appears that that degree of control is way too low for authorship to subsist. So this is a little bit on where we stand on prompts and generative AI. But I had a feeling that this was clear. But I poked my... So this is the conclusion. Yes, AI-generated works where we're actually unsure of the human intellectual creation, and in fact, there is an absence of such detailed conception and controlled execution, should not benefit from copyright protection. So we have actually ended up in a situation in which there are problems, though, in practice. So works are being submitted to the copyright offices, in particular, the American Copyright Office, which has to handle these registrations. And there is the practical aspect of having to deal with that kind of works. It is one thing to talk about that absence of degree of control here in this vacuum room, but going out there, we need to be dealing with these works. So here is where transparency and the role of registries starts to become a little bit more important. The American office has started to push for more transparency in actually explaining how this creative process took place. Applicants, in their guidance from 2023, they say applicants have a duty now to disclose the inclusion of AI-generated content in a work. And in addition to that, provide a brief explanation of the human author's contribution to the work. And to the ears of anyone really who has studied the lack of formalities and believed in that, this is a bit controversial. The necessity, and for any creator, the necessity for any creator to actually explain how they got to the output might even sound offensive. But I think that we are living in a very different world nowadays with that kind of works. So we should be a little bit more open to that possibility of being asked for an explanation on how you actually generated the work. So that kind of approach might, and this is a question mark, might create issues for formalities. But we are living, again, in a situation where there are significant difficulties in identifying actually what is the human input there. And the originality standard itself is complicated to apply. But it is, and we're dealing with an unregistered right. So the US Copyright Office, Registry Office has its own terms of reference and deals on its own way. But this is an unregistered right. It arises automatically. Now, on a journey to actually understand how it works, I've done a lot less digging into the neurons compared to Matteo, but in the past 3 months, I have been studying neuroscience on Wednesday evenings at a neighboring university to the one I work at, driven by this curiosity to understand what makes our human brains human, what makes us so difficult. Am I really getting this wrong? Aren't like human neurons the same as artificial neurons? And having done, I'm by no means a neuroscience expert, but having done these 3 months, it turns out that our nervous system is incredibly complicated, and there are and that's no surprise, but there are a lot of question marks still within that basket of science. So the first thing that struck me is that the labels that people in neuroscience put to things mean exactly the same thing, but why not have several different words? Biopsychology, psychobiology, neuroscience mean the same thing. Now, the whole thing that this is still a little bit in progress for that piece of research that I'm doing. But very often in those 3 months when we were studying the aspects of the nervous system, we hit a moment in which questions arose as to, is this a biological reaction? Is this a psychological reaction? How does our body actually respond to that stimuli, external or internal? And this is the very old mind-body problem that René Descartes first named, and he thought that the mind and the body are completely separate and they interact in the pineal gland. Later on, this theory was discarded. His dualism is no longer relied on, but the dilemma is still not resolved in neuroscience, in our understanding of the nervous system. In many circumstances, it is still debated whether we react psychologically to something and then the biological reaction comes, or the other way around. And I know that there are a lot of parallels being drawn between the human neuron and the artificial neurons. Having said that, the human nervous system interacts with all the other systems that are in there, for example, the endocrine system. And that, to my understanding, is not necessarily taking place in generative AI situations when somebody creates a work. So my preliminary conclusions are that there are lots of things that make the human human and the author. So we should still continue repeating those things. And that brings me to the societal concerns about authors. That brings me to the fact that we need to continue with that focus on the protection of authors, authorial protection, and the primary creators. Now, moving this a little bit more to the reality of generative AI and the laws that are being discussed to be reformed at the moment, primary creators, authors, artists, musicians, they often, by law, by virtue of contracts, transfer their rights to certain bigger organizations that represent their rights faithfully, but also sometimes not so faithfully. So the interest of the author does not always coincide with the interest of the right holder, and we teach this to our students when we talk about the difference between authorship and ownership, but we need to be thinking about it when we translate it into whatever remuneration systems we're thinking about in the world of generative AI and copyright. That has been also the focus very much towards the end of the European Copyright Society's opinion on copyright and generative AI from several months ago, where there is an inspiration, there is a call for inspiration from Chapter 3 of the CDSM directive, which in itself focuses on this imbalance of copyright contracts. So the focus on making actually sure that artists and performers, that's Chapter 3 of the CDSM directive, get an appropriate chunk of money in their pockets. And this Chapter 3 is really high-level principles, so we need good procedures behind this. But it's a starting point that we need to be thinking about. Just very briefly, that the Create Center, with Martin Kretschmer and Amy Thomas leading several interesting projects on this, demonstrates how difficult the income situation is for authors and for creators, and has been declining. So the picture is not really bright. So inserting something clear in the law for authors is important. And people have been writing about this. Colleagues have been suggesting solutions. In the interest of time, I'm not digging into this, but there is so-called AI-generated works levy solution that Martin Senftleben has been talking about for a while, as well as a statutory license proposed by Christoph Geiger and Vincenzo Jaia. So for those of you who would like to look more into those aspects, there are some solutions. They come with their criticisms as well, and complicated aspects. Now, moving on to my conclusions. I wanted to think about this in the grand scheme of things. So looking at the two themes of this spring conference, what does AI reveal about existing IP laws? They are for humans, rightly so. And we should be a little bit more cautious in the way that we tailor procedures, but IP laws remain for humans, and I don't think we should be changing that. How is AI changing IP? Now, we start to see a lot more transparency obligations. I have not spoken at all about the input stage, but these transparency obligations when it comes to text and data mining, training, have become more tangible in the laws in the EU. And that is also, however, going to be the case more on the output. The output is currently a little bit less under the radar and less under focus. But the discussion on registries is starting to appear again. And registries come with the big, difficult question mark around formalities. It might no longer be that offensive to talk about copyright registries. I'm not proposing a copyright registry at the moment, but the practicalities are there. So solutions such as potentially a two-tier system where we continue with the status quo for all traditional works as they are, and introducing a registry for generative AI, for AI-generated works, might actually be not that far-fetched. However, the next complicated questions to this kind of systems would be, how do you administer this in the most transparent way possible? And final thing I would like to say on transparency, and then I'll stop, is that transparency has been waived as a standard in many complicated conversations. But I have a feeling that in the laws that we are seeing now, it's becoming more tangible. It's becoming a little bit more fleshed out. Whether we like it or not, the way that it's getting fleshed out is complicated. It's driven by various interests on the policy lobbying perspective, but it is present always in the discussions. So with that, I will stop. I'm very conscious that it's 11 o'clock. Thank you.